Along with accomplice Richard Cobb, Adams robbed a convenience store in Rusk, Texas. At the time of the robbery, Candace Driver and Nikki Dement were working in the store, and the only customer present was Kenneth Vandiver. Adams and Cobb were wearing masks and after getting cash from the register, forced the two employees and the customer into a Cadillac parked in the lot and drove to a remote location. After forcing Driver and Vandiver into the trunk, Adams and Cobb sexually assaulted Dement. They later made all three victims kneel on the ground, shooting all three with a shotgun. Believing all were dead, both fled the scene. Vandiver died from his wounds, but Driver and Dement survived and testified against Adams and Cobb. Accomplice Cobb was convicted and sentenced to death in a separate trial 8 months before Adams. Evidence tied the two, met as ninth graders at a boot camp, to a string of robberies that happened around the same time. On September 2, 2002, petitioner Beunka Adams, along with Richard Cobb, robbed a convenience store in Rusk, Texas. At the time of the robbery, Candace Driver and Nikki Dement were working in the store, and the only customer present was Kenneth Vandiver. Vandiver, who was described as mentally challenged, often hung around the store, helping clean and take out the trash. At approximately 10 p.m., Adams and Cobb, wearing masks, entered the store. Cobb carried a 12-gauge shotgun. Adams ordered Driver, Dement, and Vandiver to the front of the store and demanded the money in the register. After the women complied, Adams demanded the keys to a Cadillac parked in front of the store. Driver, who had borrowed the car to drive to work, retrieved the keys from the back room. Adams then ordered the three victims into the Cadillac with Adams and Cobb, and Adams drove toward Alto, Texas. During the drive, Adams removed his mask after Dement recognized him because they had gone to school together. Adams then repeatedly told the victims that they would not be hurt, and that he just needed money for his children. At some point, Adams turned off the road and drove the vehicle into a field that was described as a pea patch. The group got out of the car, and Adams ordered Driver and Vandiver into the trunk. Adams then escorted Dement away from the car and sexually assaulted her. After leading Dement back to the Cadillac, Adams released Driver and Vandiver from the trunk, and he told the victims that he and Cobb were waiting for Adams's friends to arrive. Sometime thereafter, Adams decided to let the three victims walk away. He reconsidered a few moments later, however, the driver stated that Adams feared the victims would reach a house before he and Cobb could get away. Adams and Cobb then made the three victims kneel on the ground. He tied the women's hands behind their backs using their shirts but left Vandiver unrestrained. The victims were unable to remember who was carrying the shotgun through these events. Adams and Cobb stood behind the victims for several minutes, and the victims could tell they were discussing something, though they were out of audible range. The women then heard a single shot. Adams asked, "Did we get anybody?" And Driver answered, "No." They heard a second shot a few moments later, and Vandiver cried out, "They shot me." A third shot struck Dement. When Dement fell forward, Driver fell forward as well, pretending to be hit. Adams, carrying the shotgun, approached Driver and asked if she was bleeding. The driver did not answer, hoping the men would believe she was dead. When Driver did not immediately answer, Adams said, "Are you bleeding? You better answer me. I'll shoot you in the face if you don't answer me." The driver answered, "No, I'm not bleeding." Adams then fired the shotgun right next to her face, and, though the pellets only hit her lip, she did not move, pretending to be dead. Adams and Cobb turned to Dement and asked her the same questions. She feigned death, and the men started kicking her when she did not answer. Adams then grabbed Dement's hair and held up her head while one of the men shined a lighter on her face to see if she was still alive. Dement continued feigning death, and Driver heard Cobb say, "She's dead. Let's go." That was the only time any of the victims heard Cobb speak. After Adams and Cobb left, Driver and Dement, each fearing that the other was dead, got up and ran in separate directions. The driver had minor injuries, but Dement had been shot directly in the left shoulder. By the time police arrived at the pea patch, Vandiver, who had been shot in the chest, had died from the shotgun wound. On September 2, 2002, petitioner Beunka Adams, along with Richard Cobb, robbed a convenience store in Rusk, Texas. At the time of the robbery, Candace Driver and Nikki Dement were working in the store, and the only customer present was Kenneth Vandiver. Vandiver, who was described as mentally challenged, often hung around the store, helping clean and take out the trash. At approximately 10 p.m., Adams and Cobb, wearing masks, entered the store. Cobb carried a 12-gauge shotgun. Adams ordered Driver, Dement, and Vandiver to the front of the store and demanded the money in the register. After the women complied, Adams demanded the keys to a Cadillac parked in front of the store. Driver, who had borrowed the car to drive to work, retrieved the keys from the back room. Adams then ordered the 3 victims into the Cadillac with Adams and Cobb, and Adams drove toward Alto, Texas. During the drive, Adams removed his mask after Dement recognized him because they had gone to school together. Adams then repeatedly told the victims that they would not be hurt, and that he just needed money for his children. At some point, Adams turned off the road and drove the vehicle into a field that was described as a pea patch. The group got out of the car, and Adams ordered driver and Vandiver into the trunk. Adams then escorted Dement away from the car and sexually assaulted her. After leading Dement back to the Cadillac, Adams released driver and Vandiver from the trunk, and he told the victims that he and Cobb were waiting for Adams's friends to arrive. Sometime thereafter, Adams decided to let the 3 victims walk away. He reconsidered a few moments later, however, and driver stated that Adams feared the victims would reach a house before he and Cobb could get away. Adams and Cobb then made the 3 victims kneel on the ground. He tied the women's hands behind their backs using their shirts but left Vandiver unrestrained. The victims were unable to remember who was carrying the shotgun through these events. Adams and Cobb stood behind the victims for several minutes, and the victims could tell they were discussing something, though they were out of audible range. The women then heard a single shot. Adams asked, "Did we get anybody?" And driver answered, "No." They heard a second shot a few moments later, and Vandiver cried out, "They shot me." A third shot struck Dement. When Dement fell forward, driver fell forward as well, pretending to be hit. Adams, carrying the shotgun, approached driver and asked if she was bleeding. Driver did not answer, hoping the men would believe she was dead. When driver did not immediately answer, Adams said, "Are you bleeding? You better answer me. I'll shoot you in the face if you don't answer me." Driver answered, No, I'm not bleeding." Adams then fired the shotgun right next to her face, and, though the pellets only hit her lip, she did not move, pretending to be dead. Adams and Cobb turned to Dement and asked her the same questions. She feigned death, and the men started kicking her when she did not answer. Adams then grabbed Dement's hair and held up her head while one of the men shined a lighter on her face to see if she was still alive. Dement continued feigning death, and driver heard Cobb say, "She's dead. Let's go." That was the only time any of the victims heard Cobb speak. After Adams and Cobb left, driver and Dement, each fearing that the other was dead, got up and ran in separate directions. Driver had minor injuries, but Dement had been shot directly in the left shoulder. By the time police arrived at the pea patch, Vandiver, who had been shot in the chest, had died from the shotgun wound. In September 2002, a Cherokee County grand jury indicted Adams for murdering Kenneth Wayne Vandiver during the course of committing a felony. A Cherokee County jury found Adams guilty of murdering Kenneth Wayne Vandiver. After the jury recommended capital punishment, the court sentenced Adams to death by lethal injection. Judgment was entered August 30, 2004. On June 27, 2007, the Texas Court of Criminal Appeals rejected Adams's direct appeal and affirmed his conviction and sentence. On January 14, 2008, the U.S. Supreme Court rejected Adams's direct appeal when it denied his petition for certiorari. After exhausting his direct appeal, Adams sought to appeal his conviction and sentence by filing an application for a state writ of habeas corpus with the Texas Court of Criminal Appeals. On November 21, 2007, the High Court denied Adams's application for state habeas relief. Adams filed a successive state habeas petition which was dismissed as an abuse of the writ by the Court of Criminal Appeals on April 29, 2009. On January 8, 2009, Adams attempted to appeal his conviction and sentence in the Federal District Court for the Eastern District of Texas. The Federal District Court denied his petition for federal writ of habeas corpus on July 26, 2010. On March 31, 2011, the U.S. Court of Appeals for the Fifth Circuit rejected Adams's appeal when it affirmed the Federal District Court's order denying Adams a federal writ of habeas corpus. On October 11, 2011, the U.S. Supreme Court rejected Adams's appeal a second time when it denied his petition for a writ of certiorari. Adams filed another state habeas petition which was dismissed by the Court of Criminal Appeals on February 15, 2012. Under Texas law, the rules of evidence prevent certain prior criminal acts from being presented to a jury during the guilt-innocence phase of the trial. However, once a defendant is found guilty, jurors are presented with information about the defendant's prior criminal conduct during the second phase of the trial, which is when they determine the defendant's punishment. During the penalty phase of Adams's trial, The jury heard that Adams had participated in 2 previous aggravated robberies with Cobb. A Cherokee County man convicted of murder asked for forgiveness moments before his was put to death Thursday. Beunka Adams said there was not a day that went by that he did not wish that the night of September 2, 2002 could not be undone. He and another man robbed a convenience store and shot 3 people, 1 fatally. To the victims, "I'm very sorry for everything that happened," Adams said. "I am not the malicious person that you think I am. I was real stupid back then. I made a great many mistakes." After Adams told his family members he loved them and apologized once more to the victims and their families, the lethal injection was carried out and he was pronounced dead at 6:25 p.m., 9 minutes after the lethal dose was administered. The U.S. Supreme Court denied a request by Adams' attorneys to review his case Thursday afternoon, paving the way for the execution. The defense contended that he had deficient legal help at his trial and during early appeals. Adams had won a reprieve from a federal district judge earlier in the week, but the Fifth U.S. Circuit Court of Appeals reinstated execution Wednesday after an appeal was filed by the Texas Attorney General's office. He was one of 2 men convicted and sentenced to death for the murder of Kenneth Vandiver on September 2, 2002. Adams and Patrick Cobb, who is currently on death row for his role in the slaying, entered a convenience store in Rusk and robbed the place with a shotgun. Adams and Cobb then forced Vandiver and 2 female clerks into a car belonging to one of the women and kidnapped them. One of the women was sexually assaulted and the other, along with Vandiver, was forced into the trunk of the car when the group stopped about 10 miles away in Cherokee County. All 3 victims were forced to their knees and shot. Vandiver died as a result of the shooting, but the 2 women survived. Nikki Ansley, one of the surviving victims, witnessed the execution Thursday. She said she was glad Adams apologized, but that justice had to be carried out. "He asked for forgiveness and I forgive him, but he had to pay the consequences," Ansley said after the execution was carried out. Adams and Cobb were arrested several hours after the shootings in Jacksonville. Adams was identifiable because he had slipped off his mask after one of the women said she thought she knew him. During questioning by police, Adams didn't fully say what he did but enough to show guilt under the law of parties, said Cherokee County District Attorney Elmer Beckworth. That Texas law makes an accomplice equally culpable as the actual killer. Beckworth said evidence pointed to Cobb as the gunman, although testimony at trial showed Adams bragged to another jail inmate that he was the shooter. The law of parties became an issue in some of Adams' appeals, with his lawyers arguing trial lawyers and earlier appeals attorneys should have contested jury instructions related to the law. Assistant Attorney General Ellen Stewart Klein countered in court documents that Adams showed total participation in a capital murder and the moral culpability required of one sentenced to death. Cobb, who was 18 at the time of the holdup, was convicted and sentenced to die in a separate trial 8 months before Adams, who was 19 at the time of the crime. Evidence tied the 2 to a string of robberies that happened around the same time. A Texas man condemned for a robbery in which 3 people were shot, 1 fatally, apologized to a woman who survived the 2002 attack and family members of the slain man before receiving a lethal injection Thursday. Beunka Adams said he was a stupid kid in a man's body at the time of the crime, which started at a convenience store southeast of Dallas and ended in a remote area several miles away. "Everything that happened that night was wrong," Adams, 29, said, as he stared at the death chamber ceiling, never looking at the people who gathered to watch his final moments. "If I could take it back, I would. ... I messed up and can't take that back." His death was carried out less than 3 hours after the U.S. Supreme Court rejected a last-day appeal to postpone the execution, the 5th this year in Texas. Adams' attorneys had asked the nation's highest court to halt the lethal injection, review his case and let him pursue appeals, claiming he had deficient legal help at his trial and during earlier stages of his appeals. He won a reprieve from a federal district judge earlier this week, but the Texas Attorney General's office appealed the ruling, and the Fifth U.S. Circuit Court of Appeals reinstated the death warrant Wednesday. Adams expressed love to his family Thursday and asked those witnessing his execution to avoid letting any hate they had for him consume them. "I really hate things turned out the way they did," he said. "For everybody involved, I don't think any good came out of it." He took about a dozen breaths, then started to wheeze and snore. Eventually, he became still. He was pronounced dead at 6:25 p.m. Central Daylight Saving Time, 9 minutes after the lethal drugs began to flow into his body. Adams and another man were sent to death row for the slaying of Kenneth Vandiver, 37, who was in a convenience store on September 2, 2002, in Rusk, about 115 miles southeast of Dallas, when 2 men wearing masks walked in. The men announced a holdup, One of them was carrying a shotgun. After robbing the store, Adams and Richard Cobb, both from East Texas, drove off with the two female clerks in Vandiver in a car belonging to one of the women. Testimony at Adams' trial showed he gave the orders during the holdup and initiated the abductions. They drove to a remote area about 10 miles away in Cherokee County, where Adams ordered Vandiver and one woman to get inside the car trunk and then raped the other woman. Testimony also showed he forced all three to kneel as they were shot. Vandiver was fatally wounded. The women were kicked and shot again before Cobb and Adams, believing they were dead, fled. Both women were alive, however, and one was able to run to a house to summon help. "He asked for forgiveness and I forgive him, but he had to pay the consequences," said one of the women, Nikki Ansley, referring to Adams after witnessing his execution. She survived being raped and shot but continues to suffer painful injuries from the gun blast. The Associated Press usually does not identify victims of rape, but Ansley has publicly acknowledged it and agreed to be interviewed. Now a nurse, she said standing a few feet from Adams and watching the drugs take his life was contrary to her instincts to want to aid others. "I help people in surgery," she said. "Standing in there, it was a feeling that I didn't want to help him." Her mother, Melinda Ansley, said Adams' apology could never erase the damage he caused. "It's not going to fix the hole in her back," she said, referring to her daughter's wound from the shooting. Donald Vandiver, the father of the slain man, said Adams' execution doesn't really change anything. "As far as I'm concerned, it was way too easy on him," he said. Adams and Cobb were arrested several hours after the crime, about 25 miles to the north in Jacksonville. Adams was identifiable because he had slipped off his mask after one of the women said she thought she knew him. Cobb, who was 18 at the time of the holdup, was convicted and sentenced to die in a separate trial 8 months before Adams, who was 19 at the time of the crime. Evidence tied the two to a string of robberies that happened around the same time. Cobb does not yet have an execution date set. At Adams' trial, Adams was portrayed as Cobb's follower. The two had met as 9th graders at a boot camp. On September 2, 2002, Candace Driver and Nikki Dement were working at BDJ's convenience store in Rusk, Texas. Kenneth Vandiver, a customer described as mentally challenged who often hung around at BDJ's and helped take out the trash, was in the store with Candace and Nikki when two masked men entered the store. One of the men was armed with a shotgun and demanded money. The two men were later identified as Beunka Adams and his co-defendant, Richard Cobb. After taking the money from the cash register, Adams demanded the keys to a Cadillac parked outside. After Candace produced her car keys, Adams forced her, along with Nikki and Kenneth, into the car. As Adams drove Candace's car, Nikki said, "I know you, don't I?" Adams said, "Yes," and took his mask off. When they arrived at a remote pea patch near Alto, Cobb pointed the shotgun at Candace and Kenneth and Adams ordered them to get into the trunk of the Cadillac. Adams then took Nikki to a more secluded spot, away from the car, and sexually assaulted her. Later, Adams led Nikki back to the Cadillac and let Candace and Kenneth out of the trunk, but he tied the two women's arms behind their backs and made them kneel on the ground while the two robbers made their escape. Adams and Cobb seemingly developed a plan to leave Kenneth untied so that he could free the women once Adams and Cobb were far enough away from the scene. Adams, however, believed that Kenneth was attempting to untie the women too soon, so he returned and ordered Kenneth to kneel behind the women. Candace heard Kenneth say that it was time for him to take his medicine and that he was ready to go home. The women then heard a single gunshot. Adams asked, "Did we get anybody?" And Candace said, "No." Shortly thereafter, a second shot was fired, and Kenneth cried out, "They shot me." Kenneth Vandiver died from the gunshot wound. Seconds later, Candace heard another shot, and Nikki fell forward. Candace fell forward as well, pretending to be hit. Adams approached Candace and asked her if she was bleeding. He was carrying the shotgun. Candace did not immediately answer in the hope that Adams would believe she had been killed. Adams then said, "Are you bleeding? You better answer me. I'll shoot you in the face if you don't answer me." When Candace said, No, I'm not bleeding," Adams shot her in the face, hitting her lip. Adams and Cobb then turned to Nikki, asking her the same questions. Adams kicked Nikki for about a minute, joined by Cobb. Then they picked her up by her hair and held a lighter to her face to see if she was still alive. Candace feigned death for fear of being shot again. She heard Cobb say about Nikki, "She's dead. Let's go." That was the only time that Candace ever heard Cobb speak. After Adams and Cobb left, Candace got up and ran barefooted down the deserted country road and banged on the door of the first house she saw. After Candace had left, Nikki got up, and after walking in a different direction, found help at another house. Shortly after the women spoke with authorities, Cobb and Adams were located and arrested. From a family history, Kenneth Vandiver, for a change, had everything going for him. Kenneth was born in Dallas, a normal, everyday, run-of-the-mill kid, to hear his dad Don talk. Don and his first wife divorced when Kenneth and his brother, Jerry, were in elementary school. When Kenneth graduated from Caddo Mills High in 1983, he had already managed the local Dairy Queen for 2 years, and he was mapping out a career as an architect. Less than a week after graduation, he began summer school at Eastfield Junior College in Dallas, making an AB+ in the hardest of his core subjects. But on Labor Day, Kenneth fell asleep at the wheel of his car, and the ensuing accident resulted in massive head injuries. He lay in a coma for 10 days. With his memory and much of his intellect nearly gone, it was impossible for Kenneth to hold a job. The Vandivers moved to Rusk in 1986, specifically to open the auto parts business, something Don figured could support Kenneth when he was gone. Don said Kenneth began spending evenings at BDJ's store after he learned that one of the store's female employees was working while pregnant. He didn't like to see her mopping and sweeping, so he would do it, he said. It gave him a feeling of being useful, and he liked that. And he was upset when Sister Pate, the Reverend Jan Pate's mother, worked. He wanted to be there to help her. In reality, said Brianne Driver, the store's office manager, Kenneth committed himself to being at the store any night when a lady was working. Kenneth Vandiver was more than just a customer to Pate, he was kind of like one of the family. He spent many days sipping coffee right outside their doors. In fact, he even told them he was their guardian angel. They never knew how true those words would be. Had Candace Driver and Nikki Ansley not played dead after being shot, they too may not have survived. Driver was able to recount those frightening moments to her boss and pastor. She said while she was in the trunk of the vehicle, says Pate. The only thing she could remember was Brother Pate preaching last Sunday, keep the name of Jesus on the end of your tongue, and she said they could hear me all the way to Alto. It seems Vandiver had felt threatened by his murderers before. His parents told police Adams and a white male had been to their house for some unknown reason, now no one will ever know why. Richard Cobb also received a death sentence. The Texas Court of Criminal Appeals unanimously upheld the August 2004 capital murder conviction of Beunka Adams Wednesday. Adams and his accomplice, Richard Cobb, both Cherokee County residents, were sentenced to death for the murder of Kenneth Wayne Vandiver in September 2002. Cobb's appeal came before the State Court of Appeals in February of 2007, and was likewise denied. Adams was sentenced to death by lethal injection for what began as an aggravated robbery and culminated in the execution-style killing of Vandiver. Cobb and Adams robbed the BDJ's convenience store in Rusk and kidnapped Vandiver, a customer, and 2 store clerks, Candace Driver and Nikki Ansley Dement. Taking the keys to Driver's vehicle, the pair then drove their 3 captives to a remote field near Alto, where Adams sexually assaulted one of the girls. The victims were made to kneel, and then all 3 were shot and left for dead. Both females survived their wounds, but Vandiver, a mentally challenged 37-year-old, did not. Beckworth and then Assistant District Attorney David Sorrell represented the state at trial, and Beckworth again represented the state on direct appeal. Adams' attorney at appeal, Stephen Evans, presented 10 points of error in his client's criminal case. The court voted 9-0 that the objections held no merit. The court affirmed both the trial court's judgment and the sentence of death. Both men still have other appeals available to them. Currently, the ruling on the findings of fact and conclusions of law in the state writ of habeas corpus is pending for both Adams and Cobb. If relief is denied on the state writ of habeas corpus, the trial court will then set an execution date. That process could take between 3 and 6 months. At that point, Adams will file a federal writ of habeas corpus, said District Attorney Elmer Beckworth. When the execution date is set, the federal writ will stay that, so we are still looking at several years before the execution. Beckworth said that if the appeals process for Adams and Cobb follows the same track as other capital punishment cases he has worked, execution should take place approximately 7 to 9 years after the offense. The death sentence was warranted in these cases due to the nature of the crimes. They committed aggravated robbery, aggravated kidnapping, aggravated sexual assault, attempted murder and murder. In addition, they committed 2 aggravated robberies in the week prior to the murder, Beckworth said. Both Adams and Cobb are currently being held on death row at the Polunsky unit in Livingston, Texas. Adams was 19 years old at the time of the murder. Cobb was 18. Defendant was convicted after a jury trial in the 2nd Judicial District Court, Cherokee County, of capital murder, and he was sentenced to death. On automatic appeal, the Court of Criminal Appeals, Cochran, J., held that evidence was legally and factually sufficient to prove that defendant participated as a party in shooting a victim. Evidence in punishment phase was sufficient to support finding that defendant was a future danger to society, and defendant failed to establish prima facie case of discrimination in the composition of county's grand juries. Affirmed. Delivered the opinion of the unanimous court. In August 2004, a jury convicted appellant of capital murder. FN1 based on the jury's answers to the special issues. FN2 the trial judge sentenced appellant to death. FN3 direct appeal to this court is automatic. FN4 after reviewing appellant's 10 points of error, we find them to be without merit. Therefore, we affirm the trial court's judgment and sentence of death. On September 2, 2002, Candace Driver and Nikki Dement FN5 were working at BDJ's convenience store in Rusk, Texas. Kenneth Vandiver, a customer described as mentally challenged who often hung around at BDJ's and helped take out the trash, was in the store with Candace and Nikki when two masked men entered the store. One of the men was armed with a shotgun and demanded money. The two men were later identified as appellant and his co-defendant, Richard Cobb. FN5. Between the time of the offense and the time of trial, Nikki Ansley married, taking the name Nikki Ansley Dement. She is referred to throughout this opinion by her married name, Nikki Dement. After taking the money from the cash register, appellant demanded the keys to a Cadillac parked outside. After Candace produced her car keys, appellant forced her, along with Nikki and Kenneth, into the car. As appellant drove Candace's car, Nikki said, "I know you, don't I?" Appellant said, "Yes," and took his mask off. When they arrived at a remote pea patch near Alto, Cobb pointed the shotgun at Candace and Kenneth and appellant ordered them to get into the trunk of the Cadillac. Appellant then took Nikki to a more secluded spot, away from the car, and sexually assaulted her. Later, appellant led Nikki back to the Cadillac and let Candace and Kenneth out of the trunk, but he tied the two women's arms behind their backs and made them kneel on the ground while the two robbers made their escape. Appellant and Cobb seemingly developed a plan to leave Kenneth untied so that he could free the women once appellant and Cobb were far enough away from the scene. Appellant, however, believed that Kenneth was attempting to untie the women too soon, so he returned and ordered Kenneth to kneel behind the women. Candace heard Kenneth say that it was time for him to take his medicine and that he was ready to go home. The women then heard a single gunshot. Appellant asked, "Did we get anybody?" And Candace said, "No." Shortly thereafter, a second shot was fired, and Kenneth cried out, "They shot me." Kenneth Vandiver died from the gunshot wound. Seconds later, Candace heard another shot, and Nikki fell forward. Candace fell forward as well, pretending to be hit. Appellant approached Candace and asked her if she was bleeding. He was carrying the shotgun. Candace did not immediately answer in the hope that appellant would believe she had been killed. Appellant then said, "Are you bleeding? You better answer me. I'll shoot you in the face if you don't answer me." When Candace said, No, I'm not bleeding," appellant shot her in the face, hitting her lip. Appellant and Cobb then turned to Nikki, asking her the same questions. Appellant kicked Nikki for about a minute, joined by Cobb. Then they picked her up by her hair and held a lighter to her face to see if she was still alive. Candace feigned death for fear of being shot again. She heard Cobb say about Nikki, "She's dead. Let's go." FN6 That was the only time that Candace ever heard Cobb speak. After appellant and Cobb left, Candace got up and ran barefooted down the deserted country road and banged on the door of the first house she saw. FN6. In fact, Nikki had not died. She was life-flighted to a hospital, but she had suffered broken ribs, a broken shoulder blade, and a collapsed lung. The shotgun blast had torn away a 15 by 12 centimeter divot of skin and tissue on her left shoulder blade. In his first point of error, appellant alleges that the evidence at trial was neither legally nor factually sufficient to support the capital murder verdict because the state failed to prove that he intentionally and personally shot and killed Kenneth Vandiver. He notes that neither Candace nor Nikki actually saw who pulled the trigger of the shotgun when Kenneth was killed. FN7. Appellant argues no witness put the gun in appellant's hand during the killing of Vandiver, nor was the weapon found with the possession or control of appellant, nor was any comment even overheard by either Candace or Nikki that could be induced to conclude that appellant shot Vandiver. When deciding whether evidence is legally sufficient to support a conviction, We assess all of the evidence in the light most favorable to the verdict to determine whether any rational trier of fact could find the essential elements of the crime beyond a reasonable doubt. FN8 evidence is factually insufficient when, although legally sufficient, it is so weak that the verdict seems clearly wrong or manifestly unjust, or it is against the great weight and preponderance of the evidence. Appellant was indicted for intentionally causing the death of Kenneth Vandiver by shooting him with a firearm in the course of committing or attempting to commit robbery or kidnapping of Candace Driver, Kenneth Vandiver, or Nikki Dement, or aggravated sexual assault of Nikki Dement. The charge authorized the jury to convict appellant as a principal or as a party. The jury heard testimony from both Candace Driver and Nikki Dement that from the time appellant and Cobb entered BDJ's convenience store until they left, appellant was in charge, giving orders, and threatening the victims with the shotgun. Appellant demanded the money from the register at BDJ's as well as the keys to the car parked outside. Appellant ordered Candace and Kenneth into the trunk of the car, and appellant sexually assaulted Nikki. Later, appellant forced the women to kneel with their hands tied behind their backs. Appellant took charge of his and Cobb's escape from the scene, but then he returned and ordered Vandiver to kneel as well. When Candace heard the first shot, appellant asked if anyone was hit. When she said no, the shot that killed Kenneth was fired. Candace testified that when appellant approached her after Nikki was shot, he was holding the shotgun, and she said that it was appellant who fired the shotgun when he learned that she was not bleeding. Nikki testified that appellant lifted her by her hair and kicked her to find out if she was still alive. The jury also heard testimony from LeVar Bradley, who had been incarcerated with appellant in the Cherokee County Jail, that appellant bragged that he had fired the shotgun, because Cobb didn't have the balls to do it. From this evidence, the jury could have reasonably inferred that appellant fired the shot that killed Kenneth Vandiver. Or, because the jury was charged on the law of parties, the jury could have found that appellant, acting with the intent that Cobb kill Kenneth, aided and assisted his co-defendant in that murder. FN10 While the state's evidence may not conclusively show that appellant fired the shot that killed Kenneth, at the very least, the evidence, viewed in the light most favorable to the verdict, established beyond a reasonable doubt that appellant participated as a party. Thus, the evidence was legally sufficient to support the jury's verdict. Furthermore, the evidence is factually sufficient because it is not so weak that the verdict is clearly wrong and manifestly unjust, nor is it against the great weight and preponderance of the evidence. Appellant makes no separate argument about the factual sufficiency of the evidence except to reiterate that no witness and no testimony conclusively demonstrated that the hand that fired the fatal shot at Kenneth was his own. But that is not the standard by which either legal or factual sufficiency is judged, because the jury could find appellant guilty if he either fired the fatal shot himself or assisted his co-defendant in committing the murder. Appellant fails to make any argument that he was not involved in the robbery murder or that there was legally or factually insufficient evidence that he intended Kenneth's death and assisted Cobb in committing that act. Point of error 1 is overruled. In his fifth point of error, appellant claims that the evidence is insufficient to support the jury's affirmative answer to the future dangerousness punishment issue. FN18 appellant asserts that the state's evidence establishes nothing more than appellant was a troubled child who acted out by getting sick and had trouble adhering to the management of the juvenile authority. A jury may consider a variety of factors when determining whether a defendant will pose a continuing threat to society. FN19 We must view all of the evidence in the light most favorable to the jury's finding and determine whether, based on that evidence and reasonable inferences therefrom, a rational jury could have found beyond a reasonable doubt that the answer to the future dangerousness issue was yes. The state introduced evidence that, in the days preceding the instant offense, appellant participated in 2 aggravated robberies with Cobb. During those offenses, appellant had remained outside, and no one was physically hurt or injured. Following those offenses, appellant kept the shotgun and shells used in the robberies. Both appellant and Cobb planned the robbery at BDJ's. Unlike the other 2 robberies, appellant decided to go into the store with Cobb at BDJ's. The jury heard that during this robbery, appellant was the leader. He did nearly all the talking, including commanding Cobb and giving orders to the 3 victims. The jury also heard that it was appellant who initiated the kidnapping and was in charge during that time. At the scene of the sexual assault and shootings, appellant was again doing all of the talking and giving orders. Candace testified that appellant threatened to kill her if she did not do what he said. Nikki testified that it was appellant who sexually assaulted her. The jury also heard that it was appellant who forced all 3 victims to kneel. After the first shot was fired, appellant questioned whether anyone had been hit, and it was appellant who fired the shotgun again when Candace said she was not bleeding. Appellant then began kicking Nikki in the chest so hard that he fractured her ribs and then lifted her up by her ponytailed hair to see if she was still alive. The state also presented evidence that appellant was in charge of Cobbs and his escape from the scene of the shootings. While his statements to law enforcement downplayed his role, appellant later bragged about the shooting to another jail inmate. Further, the state produced evidence of appellant's bad character as a law-abiding citizen. Additionally, the state presented expert psychiatric testimony that appellant fit the profile of a person for whom there is a probability of future dangerousness. A rational jury could determine from this evidence that, beyond a reasonable doubt, there was a probability that appellant would commit criminal acts of violence in the future so as to constitute a continuing threat to society. Point of error 5 is overruled. In his sixth point of error, appellant argues that the evidence is insufficient to support the jury's negative answer to the mitigation special issue. This court, however, does not review the jury's finding on the mitigation issue for sufficiency of the evidence because the determination as to whether mitigating evidence calls for a life sentence is a value judgment left to the discretion of the fact finder. FN 21 appellant's sixth point of error is overruled. FN 21. Appellant was convicted in January 2004 of capital murder. Based on the jury's answers to the special issues set forth in Texas Code of Criminal Procedure Article 37.071. Sections 2b and 2e, the trial judge sentenced appellant to death. FN1 direct appeal to this court is automatic. After reviewing appellant's 8 points of error, we find them to be without merit. Consequently, we affirm the trial court's judgment and sentence of death. Appellant argues his first 3 points of error together. In point of error 1, he asserts that Article 37.071 violates the 14th Amendment to the United States Constitution because it implicitly put the burden of proving the mitigation special issue on appellant rather than requiring a jury finding against appellant on that issue under the beyond a reasonable doubt standard. In point of error 2, he alleges that the trial court erroneously overruled his motion to hold the statute unconstitutional. In point of error 3, he contends that the trial court erred by failing to instruct the jury at punishment that they could only answer the mitigation special issue. No, if the state proved a negative answer to that issue beyond a reasonable doubt. In point of error 4, appellant argues that Article 37.071 violates the 8th Amendment prohibition against cruel and unusual punishment because it allows the jury too much discretion and lacks the minimal standards and guidelines necessary to avoid an arbitrary and capricious imposition of the death penalty. We have previously addressed and rejected this claim, and we decline to revisit the issue. Jones v. State, Moore v. State. Point of error 4 is overruled. In point of error 5, appellant complains that Article 37.071 violates the 8th Amendment as interpreted in Penry v. Johnson, because the mitigation special issue sends mixed signals to the jury. We rejected this claim in Jones. The mitigation special issue does not send mixed signals, because it permits the jury to give effect to mitigating evidence in every conceivable manner in which the evidence might be relevant. Perry v. State, Tex. Crim. App.2004. Point of error 5 is overruled. In point of error 6, appellant asserts that the trial court erred in overruling the motion to quash the indictment because the grand jury members were discriminatorily or otherwise improperly selected. See Castaneda v. Partita. Challenges to the composition of grand juries are provided for in Article 19.27, which states, before the grand jury has been impaneled, any person may challenge the array of jurors or any person presented as a grand juror. In no other way shall objections to the qualifications and legality of the grand jury be heard. A person confined in jail in the county shall upon his request be brought into court to make such challenge. We have interpreted Article 19.27 to mean that the array must be challenged at the first opportunity, which ordinarily means when the grand jury is impaneled. Muniz v. State, citing Muniz v. State. If it is impossible to challenge the array at that time, then the array may be attacked in a motion to quash the indictment before trial commences. ID. However, if a defendant had an opportunity to challenge the array when it was impaneled and failed to do so, he may not challenge it at a later date. ID. On September 3, 2002, appellant was incarcerated in the county jail and had counsel appointed for him. On September 23, 2002, the grand jury was impaneled, and appellant was indicted. The prosecutor verbally notified counsel of the date that the case would be presented to the grand jury. No challenge was made to the array on or before September 23, 2002. Appellant was in custody, represented by counsel, and aware, at the time the grand jury was impaneled, that he was to be the object of its scrutiny. C. Muniz, appellant's later challenge to the array in his motion to quash the indictment was untimely. Point of error 6 is overruled. In point of error 7, appellant argues that the trial court erroneously excluded the testimony of two defense expert witnesses, Dr. Seth Silverman and Dr. Joan Mayfield, because their testimony was relevant to his duress defense. A trial court's admission or exclusion of evidence is subject to an abuse of discretion standard on appellate review. Sells v. State. If the trial court's decision was within the bounds of reasonable disagreement, we will not disturb its ruling. ID. Section 8.05 of the Texas Penal Code provides for the affirmative defense of duress if the actor engaged in the proscribed conduct because he was compelled to do so by threat of imminent death or serious bodily injury to himself or another. Compulsion exists only if the force or threat of force would render a person of reasonable firmness incapable of resisting the pressure. Appellant argued at trial that he shot the victim because he was acting under duress from his co-defendant, Beunka Adams. Appellant testified that Adams told him, "If only one does the shooting, then only one is leaving," and he believed that Adams would kill him if he did not do as he was told. Appellant made bills of exception presenting the proposed testimony of Silverman and Mayfield. Silverman would have testified that appellant was more suggestible to outside forces and less able to consider other options than an average person, because he was neglected by his chemically dependent mother as a child and suffered from depression and chemical dependency as an adult. Mayfield would have testified that appellant had cognitive weaknesses that were consistent with fetal alcohol syndrome. Thus, he was more susceptible to compulsion and less likely to consider other alternatives than an average person. The state argued at trial that compulsion was measured by an objective standard, rather than a subjective standard, and thus, any testimony from an expert that this individual is more likely to be compelled than the average person simply is not relevant or material to the issues in this case as far as duress is concerned. The trial court agreed that the duress defense was based upon a person of reasonable firmness, and was not based upon a particular defendant and the particular defendant's susceptibility to influence. The trial court sustained the state's objection and refused to allow any testimony that would relate to whether or not this defendant is more susceptible to influence or duress than the average ordinary person of reasonable firmness. Defense counsel testified that the state provided him with the letter from Beckworth at the end of the guilt phase of the trial, after Thompson had already testified. Beckworth explained that he first became aware that defense counsel did not have possession of that particular letter on the morning before final arguments. He discovered that the letter had inadvertently been placed in Adams' file and gave it to defense counsel before closing arguments. On March 25, 2004, after appellant's trial, Beckworth also discovered that the letter from Thompson to Beckworth had inadvertently been placed in Adams' file and immediately faxed it to defense counsel. Beckworth testified that the state did not make any deal with Thompson regarding his charge for unlawful possession of a firearm by a felon. Forrest Pfeiffer, Thompson's attorney, also testified that he was present at the meeting with Hatch and Beckworth and that no deals were made in exchange for Thompson's testimony. Pfeiffer explained that Thompson had not been indicted for the charge, and it was Pfeiffer's standard practice to file a motion for an examining trial in cases without indictments. Both Pfeiffer and Beckworth testified that cases in Cherokee County are routinely dismissed at the magistrate level when a defense attorney files a motion for an examining trial. Beckworth testified that he did not prosecute Thompson on the charge, not because of any deal for his testimony, but because the case was just not prosecutable, explaining as follows, with reference to Mr. Tom P. Sen's case, the offense report indicated that he was riding a four-wheeler on a location and law enforcement found him in possession of a firearm, that he was indicated to them that he was going to do some target practicing in a field or in the woods somewhere. My experience in over 20 years of felony prosecution, the citizens of Cherokee County and East Texas generally are not real fond of weapons offenses. Very difficult to get a jury in a felon in possession with a firearm. And in situations where someone is hunting the weapon as in their home or something like this where it's target practicing and there is no other crimes involved or activities indicating a danger situation, it is very difficult to get a conviction, and most of those cases are not prosecuted and are declined on the basis of insufficient evidence. In this particular case, parole was notified that we were not going to prosecute. Some of that took place through Mr. Hatch, and unknown to me until a point shortly before trial at which time the defense was made aware of it. I believe Mr. Hatch did ask Mr. Shamblin for leniency for Thompson, and I believe that was developed by the defense during the trial. The record reflects that the defense was able to argue at trial that Thompson received a benefit in exchange for his testimony. When cross-examined at trial by defense counsel, Thompson admitted that the state never showed up for the examining trial and that Hatch made a phone call to his parole officer on his behalf. Defense counsel also made the following statements in this regard during his closing argument. Mr. Beckworth wants to talk about Mr. Thompson. Mr. Thompson got a benefit. Randy Hatch called his parole officer and asked for leniency. Mr. Thompson got another benefit. When his examining trial came up, the state didn't even show up, so all charges against him were dismissed. Appellant has failed to show that the letters pertaining to Thompson were material as required by Brady. Thompson, his attorney, and the prosecutor all denied that there was a deal in exchange for his testimony. Thompson, however, acknowledged at trial that the state asked his parole officer for leniency and ultimately failed to prosecute him for the unlawful possession of a firearm by a felon charge. Even if the evidence were material, the jury was aware of the same matters referenced in the letters and was able to take this into consideration in their deliberations at trial. Thus there was no reasonable probability that the outcome of the trial would have been different if defense counsel had known about the letters earlier. Nikki DeMent testified at the hearing on the motion for new trial that she was not writing a book about the incident and that she had never indicated to anyone that she planned to write a book. She testified that she contacted the Montel Williams show via telephone, a week or so after trial had begun, and that she appeared on the show a week or two after the trial. Defense counsel testified that he did not know about DeMent's appearance on the show until after the close of the testimony in appellant's trial. Beckworth testified as follows. I had no knowledge either at the time of trial or since then concerning Nikki DeMent writing any kind of book concerning this experience. The only information I had concerning an appearance on the Montel Williams' show occurred I think the Friday evening after the first week of trial, and Ms. DeMent's father contacted me indicating that she might appear on the Montel Williams' show, and what he told me was that it was concerning something about the jobs sick people get and how they were after they are a victim of crime and how that alleviates it. During the time that the jury was out on punishment, I believe I spoke further with the Ansley family and discovered that the Montel Williams' show may be more detailed about it, but that it was not going to take place until a week or two later. I did express concern about it, but my concern was related to jury selection in the Adams case. Appellant has not shown that DeMent's planned appearance on the Montel Williams show was material evidence. He states in his brief that he could have used this evidence to argue that she was, perhaps, embellishing her testimony so as to make a greater impact, or notoriety, concerning her upcoming television appearance. Appellant, however, has failed to show that DeMent actually embellished her testimony in any way. Further, although DeMent initiated contact with the television show staff, she testified that they already knew the story, without her telling them about it. There is no reasonable probability that the outcome would have been different if the state had informed defense counsel during trial about DeMent's planned television show appearance. Point of error 8 is overruled. We affirm the judgment of the trial court. For the foregoing reasons, we affirm the district court's judgment denying Adams's petition for a writ of habeas corpus.